Good morning, everyone. Thank you so much for coming, for joining us in this very important, exciting event co-organized by CUHK Faculty of Law and UNIDROIT. So we're going to talk about a very important topic, which is the UNIDROIT principles and how important of this principle in harmonizing the international commercial contracts and activities. So we have two speakers today, and who will give an introduction of these principles and also to introduce the internship of the in UNIDROIT. And then we leave around 15 to 20 minutes for the Q&A. But before I hand over to the two speakers, let's welcome our new dean, Professor Xi Chao, to give a welcome remarks and to introduce two speakers.
Anna, well, thank you for coming today. Let me just say a few words. Today's event has to do with the future of Hong Kong. As you know, due to historical circumstances, the Greater Bay Area, where Hong Kong is located, has got three different legal traditions. One in Hong Kong, the common law tradition, and we have two jurisdictions, the mainland and Macau, which are deeply rooted in the civil law tradition. To operate, for businesses to operate in this legal environment is costly. Can be very, very costly. It takes careful planning to navigate the very complex legal landscape to operate in this kind of legal environment. Now, one possible solution is unification, harmonization, however you call it, of the private law, so that basically businesses operate ideally in a harmonized legal system. Now, that's the reason we're having this seminar. We're having senior representatives, some of the internationally most renowned lawyers, scholars in the field of harmonization of private laws joining us today to tell us what they see as what possible way forward to bring their international experience, very deep experience to Hong Kong, to the law faculty, and really to entice a discussion that might interest not just law students, legal scholars, but also businesses in this region. Let me just very briefly introduce the two speakers. We have Professor Anna Veneziano, the Deputy, I believe, Secretary General of UNIDROIT. I believe, Anna, you doesn't need any introduction, but I would just say you're a very senior academic before joining UNIDROIT. You're a very prolific author, and you have made very, very important contribution to the field. Well, joining Anna is William. We've met in person before in Rome. William is actually the go-to person if you're looking at unification, harmonization of private law in especially in Asia Pacific region. So it's such a delight to see you again today. And what I didn't realize is our former dean, Lutz Christian Wolf, who has been a very strong supporter in this enterprise. So a few months ago, I applied for this project from the RGC, the Research Grant Council, on harmonization of private laws in the Greater Bay Area. Lutz was one of the most important supporters. And thank you so much, Lutz, for coming. All right, so without further ado, let me just hand the floor back to you, Yemi.
So now let us invite Professor, two speakers from UNIDROIT to give the presentation. Yeah.
Thank you very much. First of all, allow us together to express our delight in being here with you. And we are very thankful for the invitation. Thankful to the university, the law faculty, and to Dean Professor Xi Chao, and also to all the colleagues I understand are attending today and the students. So it is not only an honor, but also we think a particular pleasure to be able to discuss with you. So not just present, but also discuss our organization, the work that we do, and in particular, the work on contract law. today. And on top of it, to speak about the opportunities of cooperation and collaboration with faculty, staff, and with the students. So allow me to start with the presentation. I hope you will indulge me because many of you might already know about UNIDROIT and what UNIDROIT does and what are the main projects we are now working on. But I thought I would give a more general introduction to the institution, to our methods of work, and then I would focus on the UNIDROIT principles of international commercial contracts. There are many reasons why this is the instrument we have chosen. The first is a little bit more formal. It's the 30th anniversary of the first adoption of the UNIDROIT principles in 1994. And so we are very happy to participate in events around the world to talk about this important instrument. It's past, present, and future. And secondly, because we know that contract law is one of the areas where professors here and also students are particularly interested in. And it's not just the UNIDROIT principles themselves, an adopted instrument, but it's also new projects that are based on the general principles and rules of the UNIDROIT principles. For example, the project on investment contracts we know has a specific interest here by faculty members with the active participation of Professor Chin Len Lin. Sorry, because I'm unfortunately my memory fails sometimes, but I think I have said it right. So that's the first slide, which is in general on UNIDROIT. So UNIDROIT is an intergovernmental organization. So we are formed by states. And we were founded as early as 1926, so we are nearing our centennial, the 100 years in 2026. And at the time, UNIDROIT was founded as an auxiliary organ of the League of Nations, which, of course, as you all know, was a predecessor of the UN. And so, and then it was continued to work as an independent intergovernmental organization, but we still work in close cooperation with many UN organizations, not only our sister organization, UNCITRAL, which was founded after the Second World War, but also the HCCH, so the three sisters in the lawmaking process of private and commercial law. But also UN agencies which specialized in specific fields and with whom we are now closely cooperating to put together the different expertise. So we have the law expertise, the academic expertise, and then the other organizations provide interdisciplinary input in our work and also the knowledge on the field. For example, FAO and IFAD for our work on law, private law and agriculture, ICAO for our Cape Town Convention on International Interest on Mobile Equipment and the Aircraft Protocol, but also other organizations, regional organizations, for example, APEC. My colleague Will represents UNIDROIT in the cooperation with APEC, which is an excellent one, I must say, and development banks such as for the region ADB and AIIB, who participate with representatives very actively in our work. So 65 member states, the two most recent accessions come from Asia. We are particularly proud of it, Singapore and Mongolia. So already you can see the map, all continents are represented. I must say that some of them, particularly Africa, is underrepresented, so we are working on that. But I would also like to say that apart from the fact that our constituency already covers a very large percentage of world's population. But it's important to note that many non-member states are actually connected with us because they have ratified at least one of our treaties. Of course, they have also benefited from other soft law instruments, but it's easier to count numbers of treaty accessions. And in particular, the two treaties which are more successful in very different fields, the Cape Town Convention, which facilitates financing for high-value equipment, with the aircraft protocol has reached now 87 states around the world, plus the European Union as economic integration organization, and counting, because every year we have to update our map, and every 6 months we have to update our map on the Cape Town Convention. And the other instrument, which is continually growing in its contracting state, it's the Rome Convention of '95 for the protection of cultural property. So if we count all those states, then we have a much higher figure of connected states. But of course, we are actually also working on the possibility of more states joining us. So in relation to, thank you so much. What does UNIDROIT do? We have a statutory aim, which is to modernize and to coordinate international private and commercial laws. So this is our scope through the development of different instruments. You are certainly very familiar with global instruments. So the most traditional, when we started work at the beginning of last century, was certainly the multilateral treaty, the convention. It was legislative unification mostly, but we are now particularly focusing on other ways to harmonize private and commercial law. And soft law is very diversified, as you know, and it allows us to, on the one hand, develop instruments in areas where it would be very difficult to find a consensus around a diplomatic table. And on the other hand, also to develop instruments that are more flexible, that can be adapted to the needs of regional or national economic and social needs. The best example in this respect, I think, it's the difference between, for example, a treaty like the Cape Town Convention, which is binding both from an public international law perspective and from a legislative perspective in the domestic state, but still flexible because states can make declarations and therefore adapt it to the needs of the country. But at the same time, then we have model laws. The most recent model law on factoring, very technical instruments. Will was in charge of that. The model law on warehouse receipts, again, a very specific instrument together with Ancitral, our sister organization, adopted both of them in last year, and important for the financing for small to medium enterprises. They don't have other capital than their own receivables, credits, or the goods that they trade with, and they are put in warehouses. So the idea is to raise financing based on these values, and those two instruments have this purpose. So, but they are model laws, so they are actually aimed at legislators, so they are more detailed because of the technicality of these particular areas. But for example, the work we have done in private law and agriculture is legislative guides. It's more of a suggestions of best practices that countries can adopt in different ways, depending on the economic and social development of the country. So usually, as you know, the traditional aim of unification harmonization was to facilitate international trade, to have rules which are harmonized, and therefore you have a lower transaction cost, you have facilitation in commercial relationships. The UNIDROIT principles are a good example of that. But we do develop also instruments that more and more foster economic and social development, so might be adapted to in domestic law. And we try also, because we are asked to do that. It's not that we produce our own work program, but we are asked by other organizations or member states to work on certain areas. And because of our specialized expertise and the flexible way of work, we're usually asked to do work in very specialized areas of commercial law. And so we try to develop these cutting edge best practices, for example, in technology and the law. The latest digital asset and private law principles that we have adopted last year go in that direction. But we also have, for example, now a project which is attracting a lot of attention, brought to us as a proposal of ISDA, which is a project on the verified carbon credits, so their legal nature and how to trade with them. Which is, of course, an important element of the sustainability agenda that we now have and many other organizations have. So allow me to show, as the last more general introduction to UNIDROIT, this slide. I'm not going to go into the details. This is just for you to have an idea of the areas of work of UNIDROIT in the past, but also now in the present. So which are the adopted instruments we are promoting, which are the projects that are still ongoing. And this also allows me to say something about the trends in the development of uniform laws and instruments. Because first of all, you see that there are two different colors. So there is a light blue and a darker blue. And you may imagine that the darker blue, light blue are the treaties, so hard law. And you see that there are much more soft law. There's much more lighter blue in our instruments. There are reasons for that. You know that. We have already referred to it. So treaties are more and more difficult to negotiate and to approve, and they might not even be the right instrument for certain areas of the law, as we have seen. Still, there are some treaties that work. And for example, the Cape Town Convention is one of them because it was developed for a specialized, they're very specialized financing in a certain specific field, which requires an international consensus. It requires hard law because it has an international registry, so you have to have a hard law to build that. And at the same time, it is strongly backed by the interested sectors of the industry. And that's the only way such a treaty can really have traction and be approved by states. In any case, even the Cape Town Convention, which is so successful, you see that we have the latest, well, this year we're very happy because the second protocol, the rail protocol for the financing of railway and rolling stock has just entered into force. So we think this is a protocol for the future because of the importance of railways, but it's a great milestone. But at the same time, we have the latest protocol, which was approved in 2019, the Mining, Agricultural and Construction Equipment Protocol. So key areas, particularly, but not only in developing economies. And that protocol took 13 years to negotiate. Even if there were no political discussions, there was no reason not to agree on the fourth treaty of an international convention, which was already approved by an incredible number of states. So, and then can you imagine the time of the implementation of the treaty? So that's why there is a shift to soft law. But as I said, it's not only for this reason, but also for the flexibility of soft law and the fact that it can be used to work in different areas. Second point I wanted to make on this slide is we are enhancing our cooperation with other organizations. I have already talked about that for the cultural property, for example, of course, UNESCO, but for other areas, the specialized organizations, not only intergovernmental organization or UN organization, but also representatives of the the sectors of the industry that are interested in this area, and development banks. So third point I would like to make is the areas of work. And then I'll stop here for the general part. So traditional areas, contract law. Of course, UNIDROIT is very much known because of the UNIDROIT principles of international commercial contracts. I would like to say something about in a short while. On the basis of the UNIDROIT principles, we have worked and are working on other contract law projects. The open one is the one on investment contracts with the ICC World Business Law Institute. Another typical area of work of UNIDROIT is access to credit with the Cape Town Convention, of course, but also with the model laws I have already mentioned and future work in our work program. We also have this traditional more private law area, but it still has a commercial element, which is the protection of cultural property. There we are an unicum in a way as among the three sister organizations, with an open project on art collections that it's now undertaken. But we also have new areas of law, and those are in particular the relationship between law and technology, which is now pervasive in all instruments, but the specific instrument is the UNIDROIT Principles on Digital Asset and Private Law, approved in 2023. And the area of private law and agriculture I have already referred to, but also the area of sustainable development with this project on BCCs, initially based on work together with UNCITRAL and the HCCH, and now more specifically focusing on the private law, commercial law aspects of the transfer and the use of these instruments, which is done at UNIDROIT. And finally, allow me to mention also a completely new area of work, which is the area of bank insolvency. That's something we did not have before. It's a project which has attracted a lot of attention. If you're interested in this sector of the law, I would invite you to have a look at the consultation that it has just concluded, but the document for the consultation was available and is available online, because it is a project focusing on the liquidation of non-systemic banks. So filling in the gap of the international standards that are actually focusing on systemic banks, and therefore providing relief and help for the situation where there is no harmonized guidance, but even domestic laws are very different in their approaches and sometimes not satisfactory. And this is why we're doing it together with BIS. And I think, if I'm not wrong, it's the first time that that organization engages with an intergovernmental organization for a project of this kind. So let me now talk about the UNIDROIT principles. We are very proud of this instrument because of its success in many areas. So I have taken the liberty of putting the cover of the Mandarin version of it, of the 2016. It's one of the more or less 17 languages in which the UNIDROIT principles have been translated. This is, of course, the English version we brought. You probably know that they were approved in 94, 30 years ago. The latest edition is 2006, I'm sorry, 2016. They are based, and this is their strength, the methodology that was used in developing them. They are based on extensive comparative law studies. And those studies were carried out over many decades because, as you know, they are based on the work that was done on sales contract first at UNIDROIT and then at the UN, at UNCITRAL with the CSG, and then again at UNIDROIT on contract law in general. But it's very important to note that it's not only the comparative studies which are, of course, relevant, but also the attention to international commercial law practice. Because the idea was to provide an instrument which would be useful, which could be solve problems of contract law in a practical way. And therefore, not a dogmatic kind of instrument, but this is how usually harmonized instruments are developed. And it's non-binding, it's soft principles and rules. They cover now the most important aspects of general contract and in many legal systems, obligation law, because they also cover, for example, set-off or assignment, for example, time limitation. But the latest edition, as you may know, is also strengthening the rules, comments, and illustrations regarding long-term contracts. So, of course, the principles were already applicable to this area, but we wanted to clarify all the ways that they can be useful in that particular setting. And I must say that particularly for long-term contracts, the UNIDROIT principles have very important and interesting rules because of their focus on the cooperation between the parties as a general principle, their focus on possibilities to keep the value of the contractual relationship and adapt the contract to new circumstances and many other elements that are present in the principles. Perhaps I can do it myself. Yes. Oh, sorry, I didn't. I have to go back to this. So here, I would like to refer to the different ways the UNIDROIT principles can be used. And the reason why I think this slide is important, and it's actually a reflection of the preamble of the UNIDROIT principle, the first article, which explains how the principles can be applied. First of all, we should say that they are aimed at international contracts, but internationality is actually a very flexible concept in the UNIDROIT principle. It's not the same as, for example, in a treaty like the CSG, which has to have very strict boundaries. But also it's commercial contracts, so it's not applicable to, in itself, to consumer transactions. This is the distinction. But at the same time, we have seen in practice that some judges, some in courts and legal systems, have used the UNIDROIT principles as a good point of reference to strengthen certain decisions, even for domestic contracts. So it has had a great influence also in this respect. And of course, it has been a model for legislation, as we will see. So I use the term tool for a reason. So the UNIDROIT principles are there to help parties, to help adjudicators, and to help legislators. Why not? So why not to help teachers? Because if they have been used for excellent teaching materials when you want to teach contract law, it's a good way to start in a classroom. But so it's actually, it's not a threatening kind of instrument because it's there, persuasive, if it is useful. And what I would like to underline is how it can be useful. So first of all, as a tool for party autonomy. What can parties do with it, or their lawyers? So the main idea of the drafters was the UNIDROIT principle would be chosen as the law of the contract, especially in arbitration, coupled with an arbitration clause, which works, of course. It's not the most common situation in practice, but that was the original idea. Another way is to use them, and it happened in practice, as not the formal law applicable to the contract, but the content of the contract, which also works very well because very few of the UNIDROIT principles are actually mandatory provisions or against they can be derogated from as general contract law. But the most common way we have seen the UNIDROIT principles chosen by the parties is when there is a dispute. When, for example, parties have not agreed on a choice of law clause, or there were conflicting choice of law clauses, or perhaps they have agreed on that, but they have a dispute. And therefore, the arbitrator, for example, can propose a reference to the UNIDROIT principles as a reasonable way to solve the dispute. So as a guideline to reach settlement agreements. Now, if we look at the number of cases, known cases on the UNIDROIT principles, it's about 580, I think, in our UNILEX database, which is freely consultable online. Of course, that's a part of the picture because many arbitral awards are not published, but also we know for a fact that they can be very useful even when you negotiate your contract because of the fact that they are written in all the different languages and as a kind of checklist for negotiations or to introduce clauses in the contract. They are actually useful also as a tool for adjudicators, not only arbitral tribunals. And I will provide an example on that in the next and last slide. But also in all cases where the parties, for example, have either agreed on a domestic law or could not agree on a specific domestic law. And then they refer to general principles of commercial law or the like. This is less uncommon than one may think, especially if parties come from very different jurisdictions. And so how to give a concrete meaning to those general principles. The UNIDROIT principles are a good way to do that because of their neutral character and sensible solutions. And this is a way of using the UNIDROIT principles that was actually a surprise almost for the drafters, and it was included in the preamble only after the second edition, is the use of the UNIDROIT principles as a reference point to interpret an otherwise applicable domestic law. We have many cases on that. Some of them very interesting, for example, as a kind of springboard to code reforms that were done then later on the basis of international law. And or in order, for example, to solve the situation where you have a conflict of decisions in the jurisdiction, and there is one solution is seen as more modern, as something that could be a new trend, and therefore the UNIDROIT principles can back that particular solution. There are many examples. So allow me to give just one example, which is not on this point, but on the more general point of the how the UNIDROIT principle can be useful in a specific situation. This is based on an actual case. We have a contract between a Turkish company and a company incorporated in the West Indies. The contract contained originally two conflicted choice of law clauses, one for English law. You can imagine the party that was more in favor of that, and the other one in favor of Swiss law. Now, you know that Swiss law is many times considered a neutral set of a neutral law, but in this case, it's not so neutral because you may know from comparative law that the Code of Obligation of Turkey is actually strongly deriving from the Swiss Code of Obligations. And so the other party was familiar with that law. So what happened was that the two choice of law were eliminated themselves. There was no agreement on the applicable law, and the arbitrator wanted to find a good solution. And then the arbitrator suggested the use of the UNIDROIT principles. The parties agreed because they saw that in practice, the principles solved their dispute. They said something which is a bit puzzling to me, that, they basically correspond to both English and Swiss law. Well, perhaps in the practical result, yes. You see that the arbitral tribunal applied the article on good faith. What? For English law, good faith, general principle. Yes, because it was applied in a very specific area, the duty of confidentiality, which is recognized also in the UK common law, the English, common law. So, and then some rules on the interpretation of the contract and the rules on damages. So this is just to show that one of the most common ways, the UNIDROIT principle can be, as I said, a tool in the hand of an arbitral tribunal. And I think, if I may, and this is my last point, it can be a very important tool when parties do not agree on a specific domestic law. So even if you are in the context of a legal system which is based on common law, but there might be situations where the parties are coming from different legal systems. They are both from systems that are not a common law systems, and they would like to either integrate the applicable law or find principles that are more generally adopted or accepted or acceptable. And therefore, in this case, the UNIDROIT principle offer a good alternative solution or complementary solution. So I think I will stop here. Perhaps I spoke even too much. Sorry if I did that. And
thank you so much, Anna, and thank you to our friends here at CUHK. Good afternoon, everyone. It's a pleasure to have the first opportunity to speak to you all now this afternoon. I have the easy job today. My colleague, my Deputy Secretary General, explained what UNIDROIT is, what we are meant to achieve, how we work, what our major areas are, and then used our most successful soft law instrument as an example of that kind. I have the easy job. I'm talking about our non-legislative work. I'm involved primarily on the legislative side, on our secured finance and access to credit instruments, but I will not be speaking about them today. I want to talk about, hopefully, how the faculty, the graduates, and the current students can become involved in UNIDROIT's work. I'm sure that Anna's presentations convince you that it's worthwhile spending time working with UNIDROIT. So as an intergovernmental organisation, we are a legislative body. That is our job. That is what our member states pay us to do. And that is what we are focused on. We have produced over 30 instruments over our 98-year existence. But UNIDROIT has a curious history, as noted by Anna. We have an academic orient to our background. We were almost like a think tank in how we first generated our instruments historically. So that makes us quite different to our sister organisations, the Hague Conference on Private International Law and the United Nations Commission for International Trade Law. We have this academic background to our nature. And to reflect this academic background, UNIDROIT created what is called the UNIDROIT Academy in 2021, which is essentially a grouping of all of our non-legislative activities. So this was to unify all of the things that we do, not directly related to the negotiation of new instruments or the implementation of existing instruments. And it really is very, it's very much in harmonization with the actual work we do, because of course, the success of our instruments depends on the negotiating a high quality instrument, which involves recruiting the most talented and knowledgeable legal experts in the world to assist us in developing the instruments. But of course, then implementing them around the world, again, requires a network. And that is in part what the UNIDROIT Academy intends to do. Now, I want to leave time for questions, so I'm going to skip most of my slides. We're very happy for our slides to be shared with everyone today. We are not going to go through all 8 areas of the UNIDROIT Academy, but I did want to put them up here, and in your own time, you can review each of the areas just so you have a full sense of what we do. But these are the 8 areas that comprise the UNIDROIT Academy. But I'm going to focus on just 2 very quickly: the Scholarship, Internship and Research Program, which in one of my different hats I manage, as well as a particular academic institute that was just launched this year, the UNIDROIT Asian Transnational Law Centre. But I do have to quickly mention the library, in part because your Dean, Charles, had the opportunity to visit and can hopefully attest, perhaps in the discussion, to the value it has. We are very proud to have one of the leading private international law libraries in the world built into our headquarters in Rome. Huge range of periodicals, greatest minds in the area coming to spend time researching, participating in negotiations, delivering lectures, and we're very proud of this, which again distinguishes us from many other intergovernmental legislative organisations, and also provides a physical hub for all of our non-legislative activities. So the Scholarship, Internship and Research Program has been running for over 3 decades. It has brought hundreds of scholars from around the world to UNIDROIT at different stages of their career to conduct research and to work on the negotiation implementation of our instruments. It's extra budgetary, so it is not paid for by our member states. Since 2012, we have relied on the benevolence of donors to support the program. So it has somewhat of a limited scope, but we have continued to run it because of its importance. So essentially, there are 4 parts to it. There are scholarships and research positions, internship positions, a specialised scholarship, and secondments. So I'm going to focus on the scholarships and research and the internship part. Scholarships and research positions are aimed at essentially PhD graduates and academics themselves, people who have finished the first part of their legal education and are not only in the early parts of the career, but also in the later parts of their career. It is for legal experts in areas of international commercial law and international private law who are working on subjects that are complementary to our instruments. Ideally, they're directly related to our instruments, but you don't have to be undertaking research exactly on UPIC. It can be, in general, international commercial contracts that has some relationship to our work program. It is very much independent. These are often very senior, prestigious individuals that receive these scholarships. So the recipients come to UNIDROIT for 1 to 2 month periods, sometimes longer, to undertake independent research associated with our instruments, to deliver lectures, but it also gives you the opportunity to meet with the Secretariat, to meet with staff, and to attend negotiations and events associated with their areas of research. So this is for the people more advanced in their career. The internships is very much aimed at students and recent graduates. We tend to take undergraduate students only in their final years if they have a longer program. But to be honest, because of the level of competition, it is more usually LLM students and PhD students or recent PhD graduates who actually receive the internship positions. The internship program provides a unique opportunity to involve yourself in the negotiation of international instruments and to see how they're made. We incorporate interns directly into the Secretariat to support the work. So if you're working with Anna, you'll be working on international commercial contracts. You'll be working on best practices in effective enforcement. You'll be working on the implementation of the rail and space protocols. If you're working with me, you'll be working on the mining, agriculture and construction protocol or on receivables finance. So it's quite a unique opportunity that is quite different to what a law firm would offer or what a university would offer. These are usually 3 to 6 month internship periods, and it provides a very good grounding on the types of instruments we work on, but also the intergovernmental nature of UNIDROIT and what it's like to work for an international organisation. So we have an official window of applications between essentially June, July and August each year. It's a very competitive process. We usually have hundreds of applications each year. I can give you a sense of some of the numbers here. For example, for last year, we received over 250 applications for internships, only about 20% of which are successful, and only about 5% of them directly funded by UNIDROIT. We aspire to fund everyone. Unfortunately, because this is extra budgetary, we cannot fund everyone. We're very proud to fund at least a quarter, if not more, of our recipients, which is much more than unfortunately the UN can provide. But the reality is, for the moment, majority of our recipients are still either self-funded or receive third-party funding from other institutes or from their own universities. But we're happy with this slide because it shows that at the moment, the majority of applications, and this is a recent trend, are coming from the Asia-Pacific region. There's an increased interest in the work done by UNIDROIT from the Asia-Pacific, and this is reflected in the numbers of applications that we've received from Asia. And of course, as a result of this, we generally, in the last few years, have taken more interns and scholars from the Asia-Pacific region than from other regions around the world. We ask interns and, in fact, research scholars to identify the area of UNIDROIT's work in which they would like to undertake their internships and research periods. This gives you a sense of the most popular areas. Of course, UNIDROIT principles and international commercial contracts is always the most popular, but we have a range of different areas that attract varying levels of interest. A personal hint, to any prospective people who would like to apply. Don't only apply for the most common areas. Anna does not need 170 interns for UPIC. She cannot take 170 interns. So sometimes it's worth applying for our other areas, which are still of great interest, such as agricultural law and development, access to credit, cultural property. These are still of great interest and use around the world. So that would be my personal hint if you're looking to apply at UNIDROIT. Don't just apply for the biggest, sexiest instruments. I'll skip over these slides because I really do want to have some opportunity to discuss, to take questions. Essentially, there are many different aspects to the UNIDROIT Academy, but I do want to pause quickly on our academic institutes. So this is a recent trend at UNIDROIT. Just in the last 5 years, UNIDROIT has been establishing academic institutes to partner with UNIDROIT to promote our work either in a particular area, such as transnational commercial law and international arbitration, or more recently, just this year, we established the Asian Transnational Law Centre, or the ATLC, of which I was very proud to be appointed co-director by the UNIDROIT Secretary General at its establishment. So UNIDROIT, as I mentioned, is intergovernmental. Our primary stakeholders are governments. But of course, because we're doing private law and commercial law, once the treaties are negotiated, once they're implemented through domestic law, the users are not governments. The users are not public institutions. They are private institutions. They are citizens, they are banks, they are commercial entities, they are lawyers. So the ATLC was established not to reach out to governments in the region, that's the job of UNIDROIT, but to reach out to academia, to private sector institutions, to civil society legal institutions, to involve them in the negotiation, implementation, and promotion of UNIDROIT's work. So essentially, it's just been established this year. It receives extra budgetary funding at the moment from an Asian law firm, from UNIFICATION law firm that has generously provided funding for the first period. And for the first 3 years, we essentially we are bolstering our collection of Asian law books in the UNIDROIT library to try to create a stronger Asian law research hub. We're translating more of our UNIDROIT instruments into Asian languages to promote their facilitation and implementation in the region. We're introducing additional new publications. We're funding additional scholars and from Asia, interns and scholars from Asia. As I noted previously, we can only fund 25%. Hopefully this will mean that for this region, we'll be able to fund 50% of selected interns and scholars from the Asia Pacific region. And we are running different events, consultations, and meetings. So these will be both in Asia. In fact, we have our first ATLC event in Shanghai on Monday next week, celebrating the relationship between the UNIDROIT principles and the Chinese Civil Code. And we are also organising events at UNIDROIT, including an event on our first essentially webinar, our first seminar in January next year, which we're focusing on UNIDROIT's work in the field of digital assets and private law. And next year, we will be launching the International Commercial Arbitration Moot on the UNIDROIT principles. The first round will be in Asia. This is, again, very new, so we'll be very happy to share additional information about that in due course. But I will leave it there so we have a few moments for questions. Thank you very much for your attention. And again, it's an honour for us to be here at your wonderful university. Thank you.
Thank you very much, Anna and Viv, so for sharing with us the legislative work and non-legislative developments within UNIDROIT. So now we have around 10 minutes to take questions. So perhaps you can, we welcome any questions on the UNIDROIT principles or other important works developed by UNIDROIT, or the opportunities like scholarship and internship questions. Yes.
Thank you for your presentations. Thank you very much for your presentations. I have 2 questions, if you allow me. One question about work of UNIDROIT, and I'm interested to hear from your real personal opinions, maybe, because my research actually is related to also the harmonization of laws. So one of the issues I am struggling right now, and maybe you can help me with it, is the nexus between contract law and the policy goals and policy developments, including so-called sustainable development goals. So it seems there is a dispute in the medical academia whether SDGs can and shall affect contract law and UNIC in particular. So from what I hear today from you, it seems like you are already took a certain position on this issue. And it seems like the project on the international investment complex suggests that you believe, and UNIDROIT believes that SDGs can and shall affect contract law. If it is, then how? Because to be honest, from my personal perspective, I struggle to understand how it can be implemented in practice. This is the first question. And second question, I'm very interested also to hear about the opportunities. You can understand, for me, most likely the most appropriate one would be the research position. So I just Google it and understand you can apply it anytime, right? There is no deadline for applications. If this is correct, I think
Thank you very much for an excellent and difficult question, because we are ourselves grappling with the question that you have posed. And this is the main reason why we have a new project, because we want to research and think about it. So you're perfectly right in saying that we have actually looked into the possibility to contractualize the approach to SDGs, and we have already done it in some of our projects. So, for example, the work on private law and agriculture, and in particular, the instrument that was approved together with the IFAD on land investment contracts, is a sort of more narrative kind of instrument, because it's a legal guide following the life cycle of the contract, but it does contain parts which are aimed at fulfilling the goals, the UN Sustainable Development Goals, in practical ways. Because, for example, they suggest ways to integrate into the investment contract agreements for the shared use of the land, or for the participation of the communities or which lived on the land itself in some of the activities that are, or the production that is undertaken at a more industrial, more general level, or of course it underlines the importance of due diligence and how to conduct this due diligence in a reasonable way, which means that there should be ways of finding not only compensatory remedies, which might not be sufficient, but also adaptative remedies, and the possibility, therefore, for example, to solve disputes in a constructive way. And we have tried to put all this knowledge together with the developments in bilateral investment treaties and in the thinking on investment law in the new project based on the UNIDROIT principles, which have some rules which go in the direction of allowing this kind of cooperation. But it's much more technical in nature and for international investment contracts. And I'm of course looking at the expert participating in this work for us, but the idea would be not to define what the standards are. I mean, this is for other organizations to do, but to work on the technical way contracts can incorporate them, the contractual mechanisms to incorporate such standards and to make them work throughout the global value chain. So in this respect, of course, there is a question of effectiveness of enforcement, but we are trying to couple this, the clauses which introduce obligations and rights in a sort of balanced way with mechanisms to solve disputes, which is what you really need to have in this respect. And we are still grappling with some of these issues, so it's not a finished work. And one of the things we are working on in that project is, for example, a due diligence clause. Apart from all the impact assessment, which are also considered to be important, or the sharing of information and knowledge. So this does not give you an answer, but I hope it's the start of an answer. Thank you.
Thank you. And Anna's answer was perfect. I think it's important to emphasize that it's not that UNIDROIT takes a position on the SDGs. As Anna said, we are not the right body to be fighting about what sustainability goals are, what environmental standards are, what labor standards are. But to the extent they're being implemented right around the world now in international commercial contracts, that's where we come in. We understand, okay, you've got these policy goals that both parties want to reflect. How do you reflect that in a proper commercial contract? What's the due diligence? What's the enforcement? So it's not that we've taken a position on those. The reality is that it's happening, and we were asked by stakeholders to help develop the contractual law standards for them. So that I hope, but as Anna said, it's not the easiest project, but a very interesting, important project nonetheless. Thank you for your question on the research program. You're absolutely right. That there are essentially two streams. There is the annual intake period each year, and that's only required if you want to apply for UNIDROIT funding. If you want to receive funding from the Institute, you must apply during this June, July, August window, because we need to competitively rank the applications. Otherwise, if we did it in an ad hoc way, it would be impossible to choose people fairly. So that being said, if you're self-funded, if you have funding from a third party or your research institute, you can apply at any time. Provide your CV, provide your research topic, provide a recommendation letter from Chow or another member of the faculty. And as long as it's well tied to our work and we have room in the UNIDROIT library, we are very happy to take researchers and academics from around the world, as well as interns, on an ad hoc basis. I hope that helps. Thank you.
Thank you. Perhaps we can take another question from the audience. So I actually have a question for Anna and Will. So I was wondering, like especially the UNIDROIT principle, there are many principles over there. So I was wondering, which principle do you think is the most important or influential, at least in Asia or in Hong Kong? And so this is a question on the substantive issue. And also for Will, I have a question on the source of these internship opportunities. So you mentioned that it's kind of like selective competitive in these very popular areas. So, but I was wondering what is the, whether other areas, which area is more likely to be selected, is less competitive, and whether there is a need of the UNIDROIT for this, like the research students on this area. Yeah, thank you.
Thank you very much. So do I understand your question to refer to the content of the UNIDROIT principles themselves, or to other instruments that are labeled principles in our work program? It's so for, yes, not an easy question, because the reception of or the reference to the different articles and of the UNIDROIT principles, because they are general principles but also detailed rules, is different depending on judges and arbitrators, and also on the legal system involved, or the legislator even. But I would say that especially because of the most recent events of the pandemics and unsettling situation around the world, there is a growing attention to mechanisms to allow for adaptation of the contract to new circumstances, and to look at hardship and force majeure with new eyes. So in this respect, the UNIDROIT principles were a bit ahead of time, and if I may say so, and can provide a useful pattern, and have been cited perhaps more often for that particular part, which is not the only part, but certainly a very influential part, just because many more traditional, especially civil law, but not only civil law, jurisdiction did not really provide for useful, more detailed rules in this respect. Thank you. Thank you.
Wonderful. Thank you as well for the question about the internship program. I'm very happy to speak directly to your students on this. And I may give a slightly more general answer. I think that will be more helpful. So, Anna and I both review dozens of CVs and applications each year for interns and researchers. So if I'm reviewing 50 CVs and I need to choose 10 for interview, of which 5 I'll accept as interns, and usually the package is a cover letter, your CV, your academic transcript, and a recommendation letter. My 3 pieces of advice would be, 1, make sure you tailor your application to what UNIDROIT does. It's very obvious when a student or a researcher has written to 20 different institutes and all I've changed is UNIDROIT to UNCITRAL or UNCITRAL Hague Conference. This is 60% of applications. And I think students think they can use AI or something to trick us. It's very obvious. You don't need to be a world-leading expert on UNIDROIT, but you do need to spend at least an hour on our website, read an article, watch a video on YouTube, look at our work program and just engage with our work program and demonstrate some unique interest. We don't require you to know the UNIDROIT principles off by heart or the Cape Town Convention, but you do need to have a demonstrated interest in UNIDROIT. That's number 1. Number 2, obviously proofread your application super carefully, and you need to demonstrate a professional level of English or French. There will be both the written part, and then often we will Zoom interview our applicants. But again, because it's so competitive, if there are spelling errors or grammatical errors in the cover letter, even if you have a wonderful CV, you will often be discarded. And then finally, in relation to the research area, the most important thing is to look at our current work program. And also look on our current work program, the General Assembly assigns a priority. 3 stars is high priority, 2 stars is medium priority, 1 star is low priority. We are forced to give a majority of our resources to the high priority projects. So go to the work program, the 3-year work program on the website, find the high priority projects. They're the ones that will need the most interns. And if you can demonstrate, and scholars. So if you can demonstrate an interest in those high priority areas, you're much more likely to be selected than if you choose one of our 30 instruments that we haven't actually been actively working on in some time. And it may also be up there.
Thank you very much, Will. This is very useful, I think, for somebody wanting to apply. If I may, sometimes the low priority may be an indication of the fact that extra funding is provided. So we are not actually funding this project in the same way we fund the other projects. So, for example, the project we had on reinsurance contract was an extremely important project, but at the same time, it was low priority because we were not paying for that, so or very little of our budget. But generally speaking, what Will says, it's perfectly right. There are projects where we need more people and projects where we need less people. So that's.
All right. I think we are a little bit over time. So I just want to share that our slides will be shared to all participants and attendees. And we have recorded our session today and will also be published on our official website as well as the CUHK Faculty of Law YouTube channel. So I think I'm going to conclude this session. I want to thank Anna and William for your generous sharing and wonderful presentation, very detailed information. Thanks a lot. So please join me in giving a big round of applause to our speakers for the presentation. And thank you all for coming. And we actually have many more wonderful sessions on this related topic. Please stay tuned and check out our official website for more events. Thanks.